I'm beyond excited to be with all of you, and we are in for a sweet treat. My friend Michele Shuster from Mac Murray Shuster will be providing us with all the details pertaining to the FCC's new ruling and how this will affect you if you're purchasing leads from an internet lead vendor. Now, the HBW team and we do have a special promotion for everyone in attendance, so don't worry, I won't make you wait until the end. I will tell you right now that offer is $375 in free leads. So be sure to take advantage of that before the offer ends on Friday. There will be a QR code to scan at the end of the webinar. But in the meantime, Michele will be offering even more free resources. So Michele, again, thank you for taking time to be with us today. You have a wealth of knowledge, especially on this topic, and we are grateful to have you. Can you share a little bit of background for everybody on the call today?
Sure. And first of all, thank you for having me. This is a very interesting topic. A lot of companies struggling to get their compliance procedures and policies around it. So hopefully we can answer some of those practical questions today. I am Michele Shuster. I'm managing partner at the law firm of Mac Murray Shuster. We are celebrating our 17th year, which is hard to believe. Prior to that, I was in big law for several years, and then before that was chief of the Ohio Consumer Protection Section. And while I did not set out to be a telemarketing attorney, which, you know, that shocks that's not a childhood goal, but when I was in the AG's office is when the do not call laws were starting to pass, and so I had to become an expert in this space to understand what those laws should look like and to get Ohio's regulations right, which I do think we have the best do not call law in the nation as a result of that. Anyway, looking forward to spending an hour here with you talking about these newest developments and how you can make sure that they don't cause you to trip up in any areas.
That's right. Well, we're glad to have you again here, Michele. And we also have on the webinar with us Nick Wynn, and Nick's worked incredibly close with you, Michele, for what, Nick, about a decade or so now?
Yep, I think we met Michele at the Professional Association of Customer Engagement back in 2013. I think it was when our first meetup was down in Miami, or outskirts of Miami, Florida. So that's been a moment, and we've been working with you closely ever since.
Yeah, that's great. And Nick will be monitoring all the questions that come in throughout the webinar. So please don't be shy. Use that chat box. It should be in the upper right-hand corner of everybody's screen. So let's go ahead and just try out that chat box. Let us know, what insurance carrier do you represent? Is that, you know, Allstate, Farmers, Country Financial? Let us know. If you're independent, just go ahead and type in independent. So try out that chat box. We're going to be asking questions throughout the webinar, and then certainly at the end, we're going to be answering all of the questions that you have. Michele and I have planned this webinar for months now, and she's probably sick of me. I've asked so many questions, dozens and dozens of questions. So I know that you all have a lot of questions as well. So again, we're going to answer all of those at the end of the webinar here. All right, see some Lee, looks like Lee's from Allstate, great. James, independent, wonderful. Okay, a few of us, we know where that chat box is. So again, would encourage you guys to put your questions in that chat box there. Now, before we dive in, I do want to make the objective of this webinar incredibly clear. HBW Leads is hosting this webinar to prepare you for the changes that are on the horizon if you purchase internet leads. However, this new ruling, it does not affect HBW Leads whatsoever. Again, this new rule, it does not affect HBW Leads. We'll get into that more in the upcoming slides here. Michele is going to discuss that. But I want, again, that to be very clear that all of our customers on this webinar or listening to this recording, or agents that are buying internet leads right now, you will not see the cost of our leads rise, and you will not see the value of our leads decrease. So this is because HBW Leads has and always will generate each and every lead based upon organic cold calling, which means that these leads are not filling out a web form online. We make about 5 million cold calls every single week. Each record is scrubbed against the federal and state do not call list before we are calling, so you can be confident that each lead is generated in a compliant manner, and we do abide by all the TCPA compliant or rules and regulations there. So enough for me. Michelle has all the important details for you. Go ahead and take us away here, Michelle.
Sounds good. All right. So, of course, we always start with the disclaimer. While I am a lawyer and I do provide legal advice on a regular basis, actually pretty much continually, we're not providing legal advice on this webinar. If we can assist you in that way, don't hesitate to reach out and contact me. And so this is the agenda that we're going to be working off of today. First, we're going to go through what the current TCPA compliance requirements are. And for those compliance requirements, the one we're specifically talking about today, because they're the relevant ones, are the ones around consent. From there, we're going to talk about what changed after the FCC released their, as it's been dubbed, closing the lead generation loophole rulemaking. And that happened earlier this year. It goes into effect on January 27th of 2025. So lots of companies working on strategies to change their marketing to comply with these new regulations. We'll obviously get into detail about that. We'll also talk about what may have changed around the do not call regulations, and then also provide some practical guidance. What we're providing here first is some consent charts that really break this down and make it easy for anybody that's trying to figure out what it is that you're required to do. The QR code up there takes you to our website, where we keep these next 3 slides or flow charts that we're going to go through, and we keep those up to date. So feel free to go get those whenever. And so let's just first talk about the area of the law that this closing the lead generation loophole was dealing with, and that was what type of consent, or how do you get the correct type of consent in order to place calls using an ATDS, which is an automatic telephone dialing system as defined by the Telephone Consumer Protection Act, or TCPA, or pre-recorded messages. And I want to be really clear that the regulators have spoke loud and clear that an AI artificial voice is also considered one of the prohibited or requires consent, the same as an automatic telephone dialing system. So think of an AI voice the same as a pre-recorded message. Okay, so what kind of consent do you need if you're using a pre-recorded message, AI, or an automatic telephone dialing system? Let's go back one more slide. And so if you're looking at making telephone calls to wireless numbers and you're using an ATDS and it's a telemarketing call, you need prior express written consent. And what that means is you have to use very specific language. As it implies, it must be written. It has to have the disclosure that marketing calls will be made to the consumer that's giving consent, that their consent's not required for purchase, and that there will be the use of an ATDS or a pre-recorded message. And then there has to be a written signature. And we're going to talk about e-sign for just a little bit here. But so for prior express written consent is needed for an automatic telephone dialing system or a pre-recorded message. I will say that after the Facebook versus Duguid case was decided by the Supreme Court 2 years ago, in order for something to qualify as an automatic telephone dialing system, you really have to be using your dialer to create random or sequential telephone numbers and then to dial those. So if you're dialing from a curated list, you're probably not using an ATDS. Of course, check with your attorney and check with your vendors about that designation. Staying in that same line under wireless, if it's an informational call that's being placed, meaning no marketing, no attempt to sell products or services, all that's needed is prior express consent. And so prior express consent is basically when the consumer has provided their telephone number as a means to be contacted to a business, and the business is contacting them within that. Following the other side for landlines, if you're not using a pre-recorded message, and this only applies to pre-recorded messages when we're talking about landlines, then you are not required to get consent. But if you're using a pre-recorded message and you're telemarketing, you have to have that same prior express written consent. So exactly what we were just talking about. All right, let's go to the next slide. Okay, so let's move over now to the do not call analysis, because you really have to worry about 2 things here. One is the type of technology you're using, an ATDS or pre-recorded message, as we just discussed, or if a telephone number is on the do not call list. And so when you're looking at this analysis, you have to look to see, are you making a B2B call or a B2C call to start with? If it's a business-to-business call, those are not covered by the do not call laws for the most part. So, nothing to worry about there. But on the B2C side, if you are, that's business to consumer, if you are placing those calls and they are telemarketing, the consumer has to have provided consent for you to call them. And so it's basically a prior invitation or a prior written notice for consent in order not to have to scrub against the do not call list. So if you have written consent, then you go to yes, you don't have to scrub. If no, then another option is that you would have an established business relationship, which is picked up on the next slide. And when we talk about an established business relationship, there's two kinds. One is you've done business with that consumer within the last 18 months. This is on the federal level, or they've made an inquiry to you in the last 3 months. The states have very different laws, or not very different, but there are states that do have different laws, and several of them do not honor this inquiry EBR, so you have to have had a prior relationship. And then there are even some that will only honor the EBR if it's a current customer. So that's really a 50-state analysis. And if you don't have consent or an EBR, then you have to scrub against the do not call list. And so, as we were talking about at the beginning of the call, HBW Leads, they don't use the prohibited technology, pre-recorded messages, or AI, and they do scrub against the do not call list. So that's how their policies and procedures work for compliance with these laws. So what's new? We talked about this a little bit. This is the closing the lead generation loophole. And so the big change for this is, and let me just give you a little bit of background. Nick had mentioned PACE. I was general counsel for PACE for almost 12 years. And so during that time, worked very closely with the FTC and FCC as they were going through rulemakings. And I can tell you both of those agencies despised lead generation forms that had linked marketing partners, that linked to hundreds or even thousands sometimes of a list of companies, that if a consumer went through a form, didn't see all those companies, just saw the hyperlink and said yes, or I consent, or contact me, or whatever, they had no idea they were consenting to all these leads. And so it led to a lot of complaints to the regulators. Also, consumers were surprised by some of the calls that they would have received, because they may have been on a mortgage comparison website, and then after providing consent on that, all of a sudden they're getting information about debt collection and other types of products and services that really weren't related to the mortgage that they were applying for. And so this is the result of that. This is the new rulemaking. And what the FCC is focused on with this rulemaking is that if you are using an ATDS, an automatic telephone dialing system, pre-recorded message, or an artificial voice call to make a marketing call, you have to have prior express written consent. And now that consent can only be obtained on a one consumer to one seller basis, meaning marketing partner lists that are hyperlinked will not work anymore. Basically anything that isn't a single, and I'll give a few exceptions here that the FCC mentioned, but anything that isn't the single consumer consenting to that one seller through that web page. Also, the other big change was this logically and topically related, which is getting the types of calls that you wouldn't expect, because the lead form you filled out had nothing to do with the call that you're now receiving. And so what the FCC will look at is, based on the context of that website, a consumer saying they want to receive a call, is that website logically and topically related to that subsequent telephone call? I am sure we are going to see a lot of cases around this as this law goes into effect, and it's definitely an area that, as I said, you're seeing a lot of the lead generators really kind of scrambling with right now to meet all of these requirements. What we do know is, and I'm hearing it from everybody, is leads are going to be more expensive and they will be harder to come by following this method. I put the do not call rules on here also because the do not call rules, and I'll say they apply to calls and texts. So whenever I say a call, insert the word text there as well. And while the FCC didn't change the requirements for the do not call law, they did muddy the waters a little bit, because they said that they're not addressing the do not call laws because they believe those laws, because they basically say you have to get the consent of the consumer for a seller meaning one seller. So we're looking at the potential that this ruling, although not specifically in the rule, could be interpreted as meaning you need one-to-one consent for do not call rules. Definitely talk to your attorney about this. You definitely, if you're not following the model that we've talked about, you're going to need a defendable position around these issues. We'll talk about e-assign. I think that's our next slide.
Yeah, and just to add on there, Michelle, from the do not call perspective, because HBW Leads is a 100% exclusive lead vendor and compliant, since the inception point of HBW Leads, we have never shared our leads. That's 20 years that we have spent sending insurance agents 100% exclusive leads, one-to-one. So we are calling and vetting the lead for you. Your name's placed in our verified calling script. Once we have the consumer on the phone, there's a series of filters that must be met for our auto, home, and life leads. They have to meet the filters at the end of the call. We tell them that John Smith, your insurance agent, will be reaching out soon. So again, that's how you can be sure that you're receiving a truly exclusive lead and a compliant lead, because nothing is changing for us with this new ruling.
And that's really important what you just said right there, because for not only for a compliance standpoint, but and I think we have an Allstate agent on here, I heard, but Allstate recently has really been struggling with this issue of vicarious liability for the actions of their independent agents, and have been found potentially liable and getting a class certified very recently. And the issue there is that, Allstate trusting independent agents then working with lead generators. And what happened in this case was there was a complete lack of due diligence in that independent agent validating that the vendors that it was relying on to provide leads were complying with the law. Mm-hmm. So critically important. It's where most companies get tripped up, because they think they're getting leads from their vendor, and their vendor is getting leads from another vendor who's getting them from another vendor who's overseas. And the calls that they said were 100% consent opt-in, which is what I hear all the time,
right.
had zero consent. So, that type of due diligence really cannot be overstated. So important to understand, like with HBW Leads, what your vendors are doing. So this is the new one-to-one consent, all summed up in the definition. You have to have an agreement in writing with the signature of the customer that clearly and conspicuously authorizes that one identified seller to deliver telemarketing calls and texts to the consumer. I will tell you that the FCC did mention two exceptions to this identified one seller in its explanations for the new report and order. One was that you could put potentially multiple sellers in one lead form, provided the consumer had to individually check each one of those. They still have to be logically and topically related, but that was something that the FCC pointed to favorably. The other was driving traffic to the seller's branded website was one of the other ways, but those were the only two that were mentioned by the FCC in its order.
One thing I wanted to add onto your Allstate comment, my friends at Allstate, we're part of the Select Vendor Program, and they wanted to make sure that we stipulate in the very front of it that the legal guidance being provided for compliance is not on behalf of Allstate, it's on behalf of HBW Leads. So we want to make it very clear, we are not doing anything on behalf of Allstate, this is all on behalf of HBW Leads on this one.
Yeah. Okay, so what type of consent is not the prior express written consent that you need? And this is what we've talked about. It's multiple sellers or companies in a single disclosure without those checks boxes that we just talked about, or those marked, those linked marketing partners or partner companies is how sometimes you'll see it phrased. Those will no longer provide prior express written consent after the 27th of January next year. Also, it's interesting to know that the FCC didn't address the issue at all of affiliated companies. When they talk about a specific company, the question becomes, do affiliated companies that are affiliated with a company that's named in the single seller consent form also have consent. And that is something where you will definitely, if that's ever something you're looking at, you would want to definitely get a legal opinion around that, because that is not clear after this latest ruling by the FCC.
Mm-hmm. Yeah, Michelle, I know you mentioned it a moment ago, being that these lead aggregators generally are sending leads to multiple different agents across multiple different carriers. In your opinion, how do you think that this will impact the volume that's available if you're working with an internet lead provider?
So obviously, considering that lead generators were using the leads forms that were these massive marketing lists, they were getting leads that they could sell to hundreds, if not thousands of companies. That's no longer going to be an available option. And so for their business models to continue to work, they have to find a way to evolve and have higher quality leads that will be, I'm certain, more expensive is what I'm hearing, and more difficult to come up with.
Mm-hmm. Perfect.
All right, so we already talked about this, so I got a little ahead of myself there. I apologize, but this is what we were talking about with the two exceptions that the FCC had mentioned. And what talks about what is logically and topically related, again, the FCC did not provide a lot of specificity. And I will tell you, in the lack of specificity by the agency that is responsible for enforcing a regulation, which there's a whole body of law around what they can and can't do. But in the absence of that type of guidance, it'll be up to the courts to decide what these definitions mean. And those of us who've been in the industry for a while know what a nightmare that can be. Think about that definition of automatic telephone dialing system that we litigated for years, and ultimately went to the Supreme Court before a decision was made that gave us a standard definition. So, what happens when things aren't clear? There's litigation. Plaintiffs' attorneys that they are fired up for next year, but they're not waiting until next year, because we're already seeing a pretty significant increase, statistically relevant increase in TCPA case filings. So we should expect that. E-sign. This is something that, and again, those of us that have been in the industry for a long time, we remember when the FCC changed the consent requirements back in 2012 by requiring prior express written consent for calls using an ATDS or pre-recorded message. And back in that order, they had said this shouldn't be much of an issue, because one of the ways that the companies can get consent is through a recorded voice. So whenever you talk to your consumer, just get consent, keep the recording, and no problem. But the problem is the FCC mentioned in that you are able to do that, use a voice recording for a signature, because a prior express written consent form is required to have the signature of the consumer. So back in 2012, the FCC said you can use e-sign to meet those signature requirements. And so that had been interpreted forever by the industry, that if you have a pre-recorded voice of a consumer consenting to receive ATDS or pre-recorded message calls, or even do not call, that counted as a signature. Well, the FCC backed way up on that and said, what we meant to say was that you can use those methods of electronic signature through website leads, through pre-recorded voices, through signing on, iPads at events or whatever, provided you meet all of the e-sign requirements. And so what does that mean, all of the e-sign requirements? Well, if you think about e-sign, it was passed so that contracts could have a legal effect of a wet signature if it was an electronic signature. That's why we have all of these software systems that allow DocuSign and those types of things to meet the e-sign requirements. Well, that law was never passed to get consent on the internet or through voice calls. Because what it requires is you have to give the e-sign disclosures, which say that your signature constitutes a valid written signature. The consumer has to give consent for that before they can actually give consent for prior express written consent or whatever, using the DocuSign document that they're signing. And so I'm sure you're all kind of scratching your head. You're like, no one gets e-sign consent before getting prior express written consent. And that's because it's almost impossible, because you have to have a writing that they can sign in and of itself before you can even provide the consent language. And so it's a complicated subject, but what I would say is, that as we're seeing companies try to comply with this and working with them, some of the things that we're seeing are that they are getting maybe in the first screen, they'll use 2 screens to get consent. The first screen, they give the e-sign disclosures, and that this signature constitutes my valid written signature. And then on the next screen, they're getting the prior express written consent. We're seeing some forms that have a checkbox at the for PWC and then a checkbox for TCPA. I think the ones that are remaining the same as they've always been are going to be a significant issue. And so that means not waiting until January 24th, but right now the FCC has said that you need those things. So lead forms that you have now that don't meet the e-sign requirements for consent for the types of technologies we're talking about are probably not valid. There was a recent decision that came out. It involved the courts looking at e-sign, and they said that using forms that we're all used to, that did not show the consumer's intent for their signature to comply with e-sign. Not that their signature wasn't valid for prior express written consent, but for e-sign. So we already have one court decision out there on this. I suspect that plaintiffs' attorneys have been chopping at the bit for something like this, and we're going to see a lot of lead forms challenged now as a result of that ruling by a court. So e-sign, who knew we'd have to even worry about that, right?
That's right. Here we are, though.
Here we are. This is the world we live in now. So I've got January 24th on here. Technically, it's the 27th. It's, we're getting people to start a little bit ahead of time here, but as I said, the e-sign and DNC rules are already in effect. That's just the FCC providing us with some interpretation. Virtually all third-party lead forms are going to have to be modified to get prior express written consent, and it's going to have that single seller and logically and topically related aspect to it, or it will not be valid. And then also they're all going to have to be updated to make sure that they are, and that needs to happen now, meet those e-sign requirements. So lots to look at. You got to do your due diligence on these types of things. You've got to make sure you know what those lead forms look like if you're required to have consent. Otherwise, could be some pretty significant issues for you and for your agencies.
That's right. Yeah, and although this is less than 7 months away, we wanted to meet with all of you well in advance so that way you are prepared and can plan. It takes certainly a lot of time for you to find the right lead vendor to invest in, and HBW Leads and we believe that based off of the information that Michele has shared and our business model, that we would be the perfect partner if you're looking to grow while staying compliant. These internet lead aggregators are trying to pivot, they're trying to adjust, and perhaps it's time for the agents, watching this recording or on this webinar to start thinking about the same thing. Just some bonus stuff here, because everything we've talked about is really on the federal level, but we do know that the states are also in the process of looking at changing their do not call and robocall laws because they're popular and because it's a way for folks that are running for elected office to get some press because these are so popular with consumers. These are ones I just wanted to pull because they're unusual. And we find that with these unusual state developments that they have a tendency to catch on with other states. I can tell you that the AG's offices that largely drive the legislative content for these bills and laws, they meet regularly and they discuss these types of things. So you see a lot of copycat type of things that happen because of that close connection that they have. Maine is the first state to require that companies scrub against the reassigned number database before placing a call into Maine. You probably already know what the reassigned number database is, but the reason that is the reason that was created is because
the FCC was getting a lot of complaints from consumers. I wonder what I set that timer for. Apparently something's in the oven that needs to be pulled out. Anyway, so back to the reassigned number database. So they put that together because consumers were complaining that they got recently received got a new phone number from their cell company or whatever, and all of a sudden now they're getting all of these debt collection calls and marketing calls, and they didn't consent to them. And it's because the callers had no way of knowing that a number had been reassigned. And so this was something that was instituted, I don't know, maybe 7 years ago, 5 years ago. Time gets a little bit blurry, but anyway, so there is a reassigned number database, and I had lots of meetings with the FCC around this when working on issues for PACE. And the one thing that they said was that this would never be a mandatory scrubbing requirement. And so while the FCC has technically held true to their word, Maine has, apparently they did not get that memo. So now this is a legal requirement to scrub against the reassigned number database before soliciting into Maine. If not, you're violating their telemarketing laws. So Maryland is one of those new states that is redefining what an automatic telephone dialing system is. This is in response to that Facebook versus Duguid case that I mentioned. They have the prior definition, or the TCPA definition, is that you have to use a random or sequential number generator and then dial that telephone number automatically. So as I said, dialing from a list is not an ATDS, but these systems, they rather look at the automation of the system, not the telephone numbers. And so if the dialer is using automation to dial that telephone number, so again, no human intervention, you probably remember that term for prior to 2021, or if it's automatically dialing the telephone numbers, which is most predictive dialers, then it is an automated dialer that would require that you have this prior express written consent, basically, but the Maryland version. Oklahoma also has this requirement. There are some exemptions in Oklahoma, so not as difficult as this new Maryland law is. Wisconsin now prohibits misleading or inaccurate caller ID, and so what this law requires is that the customer service phone number, the customer service line, is the one that has to be transmitted. This is in response to using local area codes to match the area code of the consumer that's being called, and as well as using that customer service line as your caller ID. You also have to accept do not call requests through that. For privacy laws, I just put this up because we are seeing, on a monthly basis, states pass their own state privacy laws. For the most part, with exceptions, you have to have 25 million in revenue for a lot of these types of things to apply, but some of the states are being broader in their application. We'll have to do a state privacy law update sometime. Very complicated, very tedious, and requires a significant lift to get a company to comply with all these different regulations.
Mm-hmm. Yeah, perfect. And Michelle, I know we chatted about this previously as well in preparation for today's webinar, but HBW Leads, we've made the necessary updates to these states from an outbound marketing perspective to keep you compliant. All right, beautiful. Well, I mentioned it in the beginning of the webinar. Here's that QR code. Again, scan this, reach out to us, learn how you can receive up to $375 in free leads. I hope everybody scanned that QR code a few slides ago. Free resources that Michelle is offering, and we'd like to take an opportunity to answer questions. Again, we really appreciate you all taking some time, taking this seriously, learning about what's to come and how to protect your agency, and learn what other vendors are out there and how they're taking this seriously to protect you. So we'll go ahead and I'll turn it over to Nick. I know he's been monitoring the chat box. Again, any and all questions, Michelle and I would love an opportunity to answer those for you guys.
One of the things that I was curious about, Michelle, that I'm not seeing mentioned, I thought Florida had a similar law as Maryland too, but I didn't see that included on that list of references on that one.
Yeah, so Florida's is a little bit different, but you are right. Florida has got a number of things that are unusual. Their consent is not indefinite. It expires after a certain period of time. Also, they do have that dialer definition, so you're required to basically prior express written consent. If you are using a system, and this is their definition, that automatically selects and dials the telephone number. And so it's not that or like we see in the Maryland dialer definition. I will tell you though that in Florida, this is something that the plaintiffs bar is really pushing down there, that even though the legislature in Florida changed the law to make it not as restrictive, the plaintiffs' attorneys are really trying to get cases to make it broader than it is defined. So for calls into Florida, probably worth just getting a dialer opinion. Our firm frequently provides dialer opinions we'll review dialers, and obviously if they aren't meeting the definition, then we'll issue opinions around that. But there are a number of other law firms that do that too. It's probably a good idea to talk to your lawyer just so you have that defendable position. It's all about having a defendable position so that if you ever do get a demand from a TCPA plaintiff, you can instantly respond with why you're not violating the law, whether it's because you've met the requirements around do not call, as HBW Leads has been talking about, or because you have the right kind of consent. So get that defendable position.
Perfect. There are a couple questions, but before we go into those questions, I want to reiterate our dialer that we use at HBW Lead is a non-ATDS machine. We've gone through Michele Shuster's team's review of this documents. We also gone through 2 different corporate third-party administrators of this to verify that what we have as our dialer is not defined as a ATDS due to the respect to good definition. The first question we had, the first time into leads, any common mistakes or go-to procedures?
I'm sorry, you kind of cut out there. First time, it looks like James asked, yeah, first time into leads, any common mistakes or go-to procedures as we begin? Yeah, I think this is a fantastic question because there's a lot of unknowns. What type of lead vendor makes the most sense for where you're at in your agency? Typically what we see is with newer agents, the objective might be to spend the least amount and get the most because, perhaps you have a lot of green producers. Maybe they just passed their PNC and you just want to get them volume. What I would encourage you, if that's you, is providing them with quality over quantity will allow for them to build their experience more quickly versus if they're receiving, a cheaper internet lead that's been shared. Certainly that's going to change in the upcoming months, but that might not set them up for success as it relates to them being able to work a high quality lead that is truly exclusive, which is what HBW Leads offers. We're offering you more of a quality lead versus quantity. You don't need 100 HBW leads to have a high closing percentage and a high media efficiency ratio. So for every dollar you're spending with X lead vendor, how much are you rating in premium? And that's what we focus on. We would rather provide you with a lower quantity of leads but higher quality by ensuring that you're receiving a 100% exclusive that abides exclusively that abides by all the rules and regulations and is 100% compliant. You can do just that. We do have a call cadence, James, as well. So we offer all of our new clients a free ebook, and in that ebook we outline all of the do's and don'ts, that call cadence, what does that scripting look like, different practical tips and tricks really for you.
That's a really important point, call cadence, because a lot of times it's not that the company has violated the law that would cause the issue, it's that they're overcalling leads, and that's when consumers file complaints. And when consumers file complaints, that's when issues arise.
That's right. That's right.
The next question we have from Lee here, how does this affect the old to gold, old leads that HBW calls on? I can take over this one. The main thing is that what we do with our stuff as defined, we do not call on any leads that you need prior express written consent for. These are all leads that we do not use a ATDS machine to make these calls. We also do not call on any do not call list. So that's the cell phones, are the federal, state, and even companies. So if you're with Lee, if I remember correctly, you were independent, or and so
I think Lee was with Allstate.
okay, Lee, you're with Allstate. We scrub against the Allstate corporate do not call list as well. So we have other companies that we scrub against as well. So that would not impact ours. Thank you, Lee, for answering me on that one.
All right, beautiful. What other questions do we have for Michelle, myself, or Nick?
Michelle, I imagine you worked with other people because you were with the PACE Association. What are you seeing from the lead aggregators? Are they complying? Are they going to have, because if I remember correctly, if I'm go to, let's say, QuoteBurst or a company like that that has multiple, they send their leads to multiple insurance agencies, are they going to be able to provide those, like you have to select, I want to lead from Allstate, I want to call back from Farmers, I want to call back from Country. Is that how they have to do it on their own individual things? And are we seeing those insurance aggregators being able to comply with these new rules?
So that's one way. And so having, you know, as I said, the FCC has said that if you put more than one seller in a lead form, you know, and provided we've got the logically and topically standard met, and the consumer has to affirmatively check each company that they want to hear from, then they found that as an acceptable means of getting consent. I can tell you that, you know, the companies that we see out there are doing a lot of testing right now. There's a lot of A/B testing going on to see what types of leads convert. Some are doing better than others. But obviously, having to replace that list of thousands of companies in those marketing partners list or hundreds of companies is a challenge for business models that were built around that.
So the thing that we want to reiterate while we're having this conversation is that the lead market is going to be shrinking come January of next year. January 27th is the definitive point. There's some rules and regulations that are going to be coming in before this. And so what we're trying to do is the amount of leads you're going to be able to get from internet is going to be shrinking. And so you need to find other sources like HBW that are compliant with all the laws currently and in the future, and that will be able to generate through direct marketing for this area to generate leads for you to find people interested in comparison quotes.
Yeah, absolutely, Nick. And again, you know, diversify. We can all leave this call knowing that, again, in January of 2025, you can expect a decrease in internet leads available and an increase in price if you're going to stick with your internet lead provider. But again, still consult with them, make sure that they're aware of these new rules and regulations. So HBW Leads, again, we want to inform you because, again, this is something that we've always done. We've always done one-to-one direct marketing on your behalf. Nothing is changing on our end. We are here to make sure that you are compliant and, you know, helping you grow at an affordable price. So I can't, again, thank you, Michelle, enough for providing us with these free resources and guidance. We'll go ahead and put the link. If anybody missed the QR code on an earlier slide, we'll go ahead and put that link in the chat box. So save that link. Again, free resources that Michelle is offering. And I want to encourage all of you guys to access these tools that she provided. So we appreciate everybody that joined today, and we look forward to hopefully partnering with you.
Thank you for having me. Have a great day.
Thanks, everyone.